Welcome to week 7 of hazardous waste and public law. This week we cover CERCLA liability. So how much trouble am I really in with having this toxic waste site? The scope of your CERCLA liability depends upon many things. The first thing is strict liability. Strict liability just means that you are intent-free. Whether you intended it for the soil to get contaminated or the spill to happen is irrelevant. If it happened, you are liable. The second part to consider is joint and several liability. That's a nice legal term, but basically what it means is that a person responsible for a small fraction of the waste at a site could conceivably be liable for 100% of the cleanup costs. However, the courts have held that damages should be apportioned if the harm is divisible. This comes up when there may be two parties involved in causing the spill. One party may be bankrupt. Well, the second party has to pick up 100% of the costs then. Liability under CERCLA Section 107A also requires a showing that the hazardous substances were actually disposed of. Sales and transfers of a useful product are not considered disposal. An interesting part of CERCLA is that it would appear to violate ex post facto laws, where you can actually be held liable for retroactive acts committed before the effective date of the statute. This is very unusual in law. Usually when a law is passed, it only applies to future criminal activity. There are 4 classes of persons who are liable for cleanup costs under CERCLA. The first class of persons is the current owners or operators of a facility subject to the cleanup. If you own it now, you could be liable now. The second class is past owners or operators when hazardous substances were disposed of. So if you've owned it in the past, you may be liable. The third class is generators, or any person who arranged for the treatment or disposal of a hazardous substance at the facility. And the fourth class is transporters, or persons who transported hazardous waste to the facility. The long arm of liability can find potentially responsible parties in many ways. Some of the ways you may find a PRP are through corporations, lenders of money involved in the transaction or the business, fiduciaries, estates, and beneficiaries, and actually government can be held liable for Superfund CERCLA cleanup. To make a case for liability under CERCLA Section 107, the plaintiff has to prove 4 things. First, that there has been a release or a threat of a release. Second, release of a hazardous substance. Third, from a facility. And fourth, that the release caused the plaintiff to incur reasonable costs which are not inconsistent with the NCP. These are covered in much more detail in your readings for this week.